Good morning, guys. So we had all the parties' oppositions to the Daubert motions, which were filed 2 weeks ago, where they are seeking to exclude each other's expert witnesses. Now, obviously, we also had Wayfarer filed 2 weeks ago, a renewed, very unexpected motion for judgment on the pleadings, which I thought was incredible. I thought it was very good. I know there was talk of a footnote in the judge's original order, which may have kind of put forward a sort of question that maybe they used this motion to address then subsequently. I'm hoping to get through all of these motions before the pre-trial motions hearing on Tuesday. I can't remember if that's face-to-face or over the phone. I'll have to look that up, but I'm hoping to get through all of these new filings before then. I'm going to do with the motion for judgment on the pleadings first, though, because that was an incredibly exciting argument. It was obviously unexpected, but it was the actual argument itself was very good, and I'm really curious to see how Lively is going to address this. So just to remind ourselves, basically, when the judge issued his order on 2nd of April dismissing most of Lively's claims, including the sexual harassment claims, part of the reason that the bar was there was because of the extraterritoriality argument that Wayfarer had advanced. And what Wayfarer, the crux, basically, to boil down their motion, was that, Lively was a New York resident. She shot a movie in New Jersey, and all the allegedly harassing conduct took place in New Jersey. And they're basically saying, look, she was never protected by FEHA, and she did not oppose conduct that was, quote, forbidden by FEHA. So therefore, she has no retaliation claim under FEHA. Now, if this is successful, it gets rid of the 2 retaliation claims, and that takes Wayfarer and Tag out completely. It would still leave It Ends With Us movie in for the purposes of the breach of contract for the CRA claim, but that would be it. So, let's make this a bit bigger. This is not a big filing, actually, so let's go through this. Okay. Introduction. Defendant's renewed motion for judgment on the pleadings is premised on the concept that FEHA prohibits retaliation against someone who has opposed any practices forbidden under this part. Okay, I mean, it should. That's how it should work. You can't really, invoke FEHA retaliation for, any old harassment claim, surely. Defendants assert that in dismissing the harassment claim on the basis of extraterritoriality, the court has ruled that the allegedly harassing actions of the Wayfarer parties were not subject to or forbidden under FEHA, and accordingly, Lively's alleged opposition to those actions was not opposition to practices forbidden under that statute and must be dismissed. There are 3 fatal defects of this argument. Okay, and I'm about to go and read them now, but I will say this. They're probably going to say, well, yeah, I know, but the court didn't rule on whether the conduct was harassment or not, which is technically true. He weighed in an opinion on whether individually they would meet the bar, but then he sort of said, well, taken all together, there's a triable fact here that that the jury could decide that basically Lively had a reasonable basis. And whilst that is technically true, and that is the law, I think the important point here is, at the end of the day, Lively did not meet the bar legally. So if the judge has ruled that her claims, needed to be dismissed because they did not, there was an extraterritoriality problem, and they did not meet all the elements required to be brought under FEHA, then that's a problem. That's a problem. I can't see how Lively can overcome that. And again, I do think, well, if we just applied FEHA retaliation to discrimination claims that did not sufficiently meet the legal bar for FEHA, then I feel like that would be so chaotic. Okay. First, the court neither analysed nor considered the practices forbidden under this part, language of section 12940H in its ruling on extraterritoriality, either in connection with the harassment claim or the retaliation claim. Instead, the court analysed extraterritoriality following the test articulated in Campbell. That test, as the court explained, it places an emphasis on the ultimate discriminatory acts and aligns with other courts' focus on whether a crucial element of the claim occurred in California. Defendants have identified no case, not one, even considering the extraterritoriality of underlying harassment as a basis for concluding that an otherwise territorial application of a resulting retaliation claim must fail. Their novel theory, which is presented in a conclusory fashion with minimal analysis, should be rejected. Yeah, I don't buy that. I mean, Lively can't even say the harassment that she's alleging took place occurred in California, because she's heavily weighed it on Jed Wallace, who's in Texas, for a start. Melissa Nathan, I do believe, is in California. But again, where was the harm felt? Lively's in New York. Her agents are in New York. Her husband is in New York. So the fact that that some of the defendants are domiciled in California is, again, evidence of nothing for me. Second, even if the harassment claim is barred on the legal basis of extraterritoriality, Ms. Lively's retaliation claim does not turn on whether harassment ultimately succeeded, only on whether she had a reasonable, good faith belief that the conduct she was opposing constituted harassment. Defendants do not address how Ms. Lively has failed to meet this standard. Instead, they rely on a proposition that California courts consistently reject, that a belief in unlawful harassment is not objectively reasonable as a matter of law if the claim is dismissed on extraterritoriality grounds. This is wrong. California courts are clear that a plaintiff's belief may be a mistake of fact or law and is only unreasonable if it is utterly baseless. If defendants' extreme position were correct, individuals who witness troubling conduct and who are not themselves employment lawyers, legal scholars, or judges would be chilled from reporting by a fear of retaliation if the conduct is later determined to be outside of FEHA's coverage. That chill would be even worse with respect to the presumption against extraterritoriality, a technical doctrine that can produce results that would appear counterintuitive to a layperson, including that, as the court held here, a Hollywood actress working for a California-based entity who is alleged to have harassed an individual working under a contract negotiated by her California counsel with a California choice of law provision is not protected by California's anti-harassment provision. That contract was deemed unenforceable. The ALA, which had the California choice of law provision, was deemed unenforceable. So, no choice of law provision. At a minimum, Ms. Lively's belief that the relevant conduct constituted FEHA actionable harassment was not utterly baseless, and her retaliation claim must therefore proceed. What I'm stunned with is this part of the argument. like working under a contract negotiated by her California counsel. We're back to you know, the blue jean baby New York lady argument. Hey, you know, my counsels who worked on because they would have worked on both the CRA and the ALA. Yeah, they're based in California, so therefore that gives me the jurisdictional claim here. That's not how that works. Because I'm sure her counsel, well, yeah, I'm sure that same counsel probably had offices elsewhere, you know. Her current counsel have offices dotted all over the place, so but that is a stupid argument, very weak argument, and she is just basically clinging with her nails now at this point. Because yeah, okay, she's a Hollywood actress working for a California-based entity, but you got to remember, right? She technically, whilst it ends with this movie and Wayfarer technically were kind of incorporated in California, it ends with this movie had like a base. It had offices in New Jersey where the film was being shot. So no for that. Working under a contract negotiated by her California counsel is probably the weakest argument I've seen of this entire lawsuit so far. With a California choice of law provision, no, because that was deemed unenforceable. The whole contract was actually deemed unenforceable, which ergo this particular provision of it was also unenforceable. So that's just rubbish. Okay, third. Defendant's renewed motion for judgment on the pleadings simply ignores the participation clause of section 12940H, which forbids retaliation because a person has filed a complaint under this part. Ms. Lively undisputedly did just that when she filed her CRD complaint in California. No, that's just rubbish. Having done so, she clearly engaged in a protected activity with no territorial issues whatsoever. You filed your lawsuit in New York, though. You know? But I still struggle to think, like, I'm still struggling with the argument that filing the CRD was a protected activity. There's an argument that it was, definitely, but it was so after the fact. I'm just struggling, like, what was the basis for it? Okay. As such, the protected activity element, which is the only one challenged by defendants, is met for pleading purposes at a minimum, and the renewed motion for judgment on the pleadings must be denied. I mean, that last one is probably her strongest, but I don't buy it. Because she says, well, I did this one thing, and technically she didn't. Did she file it in California? Technically, the CRD is in California. But it's not like she went there to file it. It was just filed online. I have to, I don't know. I think that's her strongest argument. But then, at the same time, the EEOC has got offices in, places like Atlanta, Denver, Buffalo, Dallas, Kansas, Cleveland, Tampa, Mobile. It's got several offices. And she also filed with them. There isn't one for California, though. In fact, I think, pretty sure their main office might be Seattle. I know they've got offices in these areas. Hold on. Yeah, so if you're filing a complaint, you file with Washington. So there we go. DC. Just to throw that argument kind of back, it's like, there is this too. Because you didn't just file with CRD, you filed with the EEOC, and go onto their website. You have to file your complaint with them in Washington. Again, I think that's more. It's not physically turning up and taking something to be stamped in person, like like you would if you were going to a court. I think that's just an online, sending it over, and they happen to be picking it up in California. But that's just not enough to say, hey, she did this because I mean, it might have come from California though, because it was signed by Ezra Hudson, who I know is an LA, a California attorney. So okay, let's go through this argument. I'm not convinced so far, but let's go through the argument, see what she says. Defendants cite no authority supporting their position that an extraterritorial bar to a harassment claim bars a retaliation claim as a matter of law. Defendants cite no case, California or otherwise, and Miss Lively is not aware of one, that examines the extraterritoriality of the harassment underlying a retaliation plaintiff's claims. In their effort to embed a second extraterritoriality analysis within the test that Miss Lively's retaliation claim has already passed, defendants' sole argument is that to the extent Miss Lively's harassment claims are not actionable under FEHA, her retaliation claims are not either. That is a flatly wrong statement of California law and an incorrect interpretation of the forbidden under language of Section 12940H. It is well established that a retaliation claim may be brought by an employee who has complained of or opposed conduct that the employee reasonably believes to be discriminatory, even when a court later determines that the conduct was not actually prohibited by FEHA. The court has already recognized exactly that principle in reviewing Ms. Lively's retaliation claim. Defendants seem to favor a rule that permits an employer to retaliate against an employee with impunity whenever the employee's reasonable belief turns out to be incorrect, i.e. exactly the regime that the California Supreme Court rejected in Yanowitz. Okay. Contrary to defendants' apparently unprecedented argument, nothing in the statutory language requires such a rule. FEHA's anti-retaliation provision prohibits retaliation for opposing any practices forbidden under this part, including harassment based on sex, or because the person has filed a complaint, testified, or assisted in any proceeding under this part. Defendants make much of the italicized language, but they overread it. Subsection H requires only that a person have opposed a practice forbidden under FEHA, not that the conduct complained of constitute an actual violation of FEHA in the sense of satisfying every element of liability. Harassment, including the creation of a hostile work environment, is a practice forbidden by FEHA. Stated differently, the practices forbidden under this part language, which defendants rely, is meant to define the types of conduct and not the types of legal violations that a person may safely report. Thus, a person who opposes conduct alleged to be sexual harassment or a hostile work environment has opposed a practice forbidden by FEHA, even if the conduct does not qualify as a violation of FEHA because some other element is not met, including because it occurred beyond the FEHA's geographic scope. That distinction explains the conclusions reached by some courts that opposing certain practices is not protected activity because those practices do not resemble a type of conduct prohibited by the relevant anti-discrimination statute. In Dinslage, which defendants rely on, the plaintiff's general advocacy for the disabled community and opposition to elimination of allegedly beneficial programs opposed a type of discrimination against disabled members of the general public that FEHA did not cover. Similarly, in Cooper, the conduct at issue fell outside the scope of the statute's enumerated protected activities, whistleblowing on environmental practices in ARN and opposing internal procedures in Cooper. By contrast, FEHA forbids both sexual harassment and the creation of a hostile work environment as an employment practice. All that is required to state a claim of retaliation is that the nature of the complaint falls within the general purview of FEHA. Complaints about perceived sexual harassment, unlike complaints about discrimination against disabled members of the public, do. Ms. Lively need only allege a reasonable good faith belief that the practice she opposed was unlawful, which she did. Perhaps recognizing a flaw in their argument, defendants devote a single paragraph to the proposition that Ms. Lively cannot prevail by showing a good faith, if mistaken, belief that defendants' actions violated FEHA. Defendants quote language from an intermediate California appellate court, in turn quoting the 11th Circuit, stating that a retaliation plaintiff's belief must be objectively reasonable when measured against existing substantive law. Defendants then suggest that this means that a FEHA retaliation plaintiff must have a correct and up-to-date understanding of the law based on the latest relevant precedents. Otherwise, protecting activities based on a belief that is legally erroneous would constitute expanding the statute beyond the categories of discrimination addressed by the legislator. That is also an incorrect statement of the law on protected activity. As this court has already recognized, although defendants conveniently ignore this, it is well settled that a retaliation claim may be brought by an employee who has complained of or opposed conduct, even when a court or jury subsequently determines the conduct actually was not prohibited by FEHA. Instead, an employee is protected against retaliation if the employee reasonably and in good faith believed that what he or she was opposing constituted unlawful employer conduct such as sexual harassment or sexual discrimination. Further, the reasonableness required to make such a belief sufficient to sustain a retaliation claim is not a high bar, as this court has recognized. The California Supreme Court holds that even if a plaintiff's beliefs regarding sexual harassment are legally mistaken under FEHA, a retaliation claim might be sustained where the nature of the complaint reasonably falls within the statute's general purview. As this court has recognized, the question is whether Lively's belief was, as some courts have put it, utterly baseless. As the California Supreme Court has explained, strong policy considerations support this rule. Employees are legally unsophisticated and will not be in a position to make an informed judgment as to whether a particular practice or conduct actually violates the governing anti-discrimination statute. A rule that permits an employer to retaliate against an employee with impunity whenever the employee's reasonable belief turns out to be incorrect would significantly deter employees from opposing conduct they believe to be discriminatory. By the same token, the California Supreme Court has explained a rule that would allow retaliation against an employee for opposing conduct the employee reasonably and in good faith believed was discriminatory whenever the conduct subsequently was found not to violate FEHA would significantly discourage employee from opposing incidents of discrimination, thereby undermining the fundamental purposes of the anti-discrimination statutes. For these reasons, the correct standard is not, as defendants suggest, whether Ms. Lively's belief that she was opposing unlawful harassment accurately reflected the state of the existing law. The only question is whether that belief was utterly baseless. It was not, including as to the extraterritoriality defects that this court identified. First, as the court has recognized, neither the Ninth Circuit nor the California Supreme Court has addressed whether FEHA may apply extraterritoriality. In the absence of a binding precedent from the California Supreme Court, this court is necessarily in the familiar but uncertain position of having to predict how the forum's state's highest court would decide the issue. Such eerie guesses are, of course, sometimes wrong. It is entirely possible that the California Supreme Court may someday conclude that some degree of extraterritorial application is reasonably to be inferred from the language of the FEHA or from its purpose, subject matter, or history, particularly in circumstances like these, where someone agrees to work on a California studio's production and is then harassed by California residents working for that California studio during the New Jersey phase of a film shoot. That also included shooting days in California. I mean, didn't she have like 2 days in California? I thought it was in Nevada. I thought she was in Las Vegas. But yeah, the New Jersey phase of the entire phase 1 was in New Jersey. It wasn't. I mean, that's a stretch as well. Well, there was some days that were filmed in California. Yes, okay, but many months away from these acts, and no acts took place there. Campbell, an intermediate appellate case, inferred that the presumption of extraterritoriality was not overcome based on constitutional avoidance principles that, whatever their force laid against Campbell's more remote facts, have little force in light of the substantial connections between Miss Lively's work on the film in California. And Campbell otherwise turned on a few phrases of legislative history, but did not otherwise consider the FEHA's purpose or subject matter. It is entirely possible that the California Supreme Court, were it to engage in the more comprehensive analysis required by its own precedents, would lead to a contrary result. Okay. The purpose and the subject matter of the FEHA suggests that an actor's protection from harassment should not toggle on and off as a film's shooting schedule takes her in and out of California. It was not unreasonable, much less utterly baseless, for Miss Lively to have believed that the FEHA does apply extraterritorially. Oh, this is such a word. At least to the harassing conduct of employees of California entities with contractual California choice of law provisions. Second, even applying the extraterritoriality analysis that this court adopted, it was not objectively unreasonable, much less utterly baseless, for Miss Lively to believe that FEHA applied given the specific facts that contributed to her expectations here. Miss Lively executed a contract between her and the ends of this movie, a California-based entity and subsidiary of California-based studio, to govern her work on a production led by California residents, Baldoni and Heath acting as producers and director. Hold on, now they're talking about the CRA. So again, I'm going to come back to the point I have now made several videos on, because this really does bother me. And if Wayfarer would argue it, I'm sure they had their reasons for not, then this would go away too. But no, she did not execute a contract between her and It Ends With Us movie. She executed a contract between Blakely Inc. and It Ends With Us movie. It's important to point this out. Unsurprisingly, for an actress who worked regularly in California-based productions, Miss Lively's California-based representatives, including her agent, her manager, and her entertainment lawyer, all negotiated that deal on Miss Lively's behalf. The production itself was planned to include and did include filming in California. The script anticipated filming in Los Angeles, and the film's production ultimately did include a few days of filming in California. Yeah, it was California. That's it. She shut down Las Vegas, didn't she? Later, it enters the movie, and Wayfarer's California-based acts and omissions were important to the conduct that occurred on set, such as their failure to hire additional HR personnel or share HR policies with the cast and crew. Further, Miss Lively's own experience of the specific harassment she suffered had a significant California nexus. As discussed above, Miss Lively was harassed by California residents and officers of the California-based entities who employed her. And when Miss Lively informed Sony executive Ange Giannetti that she was very unhappy that Heath showed her a video of his wife giving birth, Miss Lively then had a 45-minute conversation with Miss Giannetti, who was in California at the time. Oh my God. Yeah, these arguments are back. Oh, well, I phoned Ange Giannetti and she was in California at the time, so, therefore. During that conversation, Miss Lively shared her concerns, including about Baldoni's comments about her body and Heath's decision to show her the birth video. Miss Giannetti told Miss Lively that she had to report her concerns directly to Wayfarer. Miss Lively told Miss Giannetti that she wanted to file a HR complaint. Did she? Did she actually say she wanted to file a HR complaint? But Miss Giannetti instead reported Miss Lively's complaints to Baldoni and Heath, not to Sony's HR. And throughout this period, Miss Lively reasonably believed that her work on the film was governed by the ALA, which contained provisions governing her accommodations during anticipated work in Los Angeles, and also contained a California choice of law provision. FEHA's policies and purposes strongly favor the conclusion that Miss Lively's belief was reasonable. FEHA's anti-retaliation provision exists to eliminate the chill that would result if employers could freely retaliate against plaintiffs who turn out to be wrong about the facts or the law. Such a scheme would significantly discourage employees from opposing incidents of discrimination, thereby undermining the fundamental purposes of the anti-discrimination statutes. These concerns are even more heightened with respect to extraterritoriality, a technical doctrine unknown to most lay people, not tied closely to common sense intuitions, and often dependent on fact-bound inquiries and subtle legal tasks like identifying the core of the alleged wrongful conduct, go into the material elements of the cause of action. In an age of remote work, multi-jurisdictional employers, and even movies that are shot in more than one location, asking potential claimants who would like to report an unlawful conduct to first engage in an extraterritoriality, I hate that word, analysis before speaking up, where the penalty for a wrong answer is that the complainant can be fired, is a recipe for chilling reporting and contrary to the fundamental purposes of the anti-discrimination statutes. And I will say that is Lively's strongest point of argument for me. There is actually, people do move around. People might work for a company and, be seconded to various offices, around either the same country or across the world. I can see the logic there with what she's saying. I don't know whether it's enough. I don't know whether Lyman's going to buy it. He might do, given his ruling on the renewed motion for summary judgment from TAC. So far, overall, I'm not taken in by the argument, but that last incredibly long sentence was actually quite a strong, persuasive argument from Lively. Credit where credit is due. Okay, defendant's motion ignores the participation clause of section 12940H. Finally, defendant's renewed motion for judgment on the pleadings ignores the participation clause of section 12940H, which makes it unlawful to retaliate against a person because that person has filed a complaint, testified, or assisted in any proceeding under this part. Ms. Lively has filed a complaint under the FEHA, the CRD complaint. It is undisputed that the filing of the CRD complaint took place in California. And Ms. Lively has alleged and intends to prove at trial that defendants retaliated against her for filing that CRD complaint. Nothing in defendant's renewed motion for judgment on the pleadings affects her retaliation claim against that clause of section 12940H, nor could it. Again, that is her strongest argument. The kind of prongs that Lively uses, I think that is the strongest. I don't love it, and I think it's a bit too kind of basic to say, well, I filed the CRD complaint in California, because the CRD is based in California, but as I said earlier, she also filed the EEOC complaint in Seattle. That wouldn't be enough to that would not be enough to bring an equivalent action for retaliation if there was a like for like kind of FEHA type statute in Seattle. So yeah, a conclusion, defendant's renewed motion for judgment on the pleadings should be denied. Okay. Interesting. Now, Lively has actually filed a declaration from one of the experts. This would be Richard Marks, Johnny Depp's former expert witness, in support of her opposition on this motion. Okay, so it's only a few pages, so we'll go through that as well while we're here. Declaration of Richard Marks in support of Blake Lively's memorandum of law in opposition to defendant's second motion for judgment on the pleadings. I, Richard Marks, declare pursuant to this that the following is true and correct. I am over 18 years of age, of sound mind, and otherwise competent to make this declaration. This declaration is based on my personal knowledge and professional experience in the entertainment industry as described herein. I'm an attorney, duly licensed to practice law in the state of California, and I have practiced in various sectors of the entertainment industry since 1974. Is she going to try and say that one of her expert witnesses is from California as well? So therefore, where are we going with this? In addition to my years in private practice as a transactional attorney in boutique entertainment law firms, as well as a major international firm, I have acted in senior legal and business affairs capacities for a boutique literary agency, major entertainment studios such as Paramount, Disney, and Universal, and leading independent production companies such as the Kushner Lock Company, the Weintraub Entertainment Group. For the last 6 years, I practiced with my own firm, Richard Marks & Associates, an entertainment law firm representing clients such as ITV, MRC, Olive Bridge Entertainment, Jolie Productions, and many others in connection with development, production, and exploitation of entertainment content. During my career as a transactional entertainment lawyer, I've worked in legal and business affairs capacities on and in connection with many television series and motion picture productions. I've negotiated on both sides numerous agreements between talent such as writers, directors, actors, and producers, and motion picture and television studios, networks, distributors, and streamers. I previously submitted an expert report in this matter dated October 17, 2025, which addressed, among other things, entertainment industry custom and practice and Lively's lost professional opportunities. I respectfully submit this declaration in support of Miss Lively's opposition to the defendant's second motion for judgment on the pleadings. In my personal experience and within my personal knowledge, it is many times the case that actors feature in motion pictures do not sign. Right, let me just start that again. In my personal experience and within my personal knowledge, it is many times the case that actors in feature motion pictures do not sign their long-form contracts with the Hollywood studios and or production. Oh my God, is he trying to rewrite the whole decision on the ALA? Oh, it's common for people not to sign their contract. Many times that actors in feature motion pictures do not sign their long-form contracts with the Hollywood studios and or production companies that engage their services. Instead, the parties rely on signed term sheets, certificates, and or underlying deal correspondence, and or may trade drafts and comments in order to resolve and or preserve their respective positions on certain key deal terms prior to the actor commencing work on the applicable project, while leaving the lesser terms and so-called boilerplate provisions unresolved. Notwithstanding the lack of signature on the applicable contracts, in my experience, the parties proceed with an understanding that the undisputed provisions of the unsigned contract are effective and binding on all people. No, that's not how that works. This argument is going to really piss me off now. Right? If you're too fucking lazy to sign a contract, right, you don't. The judge has already said that not signing that contract meant the contract was not executed, which was an express provision from Wayfarer that it had to be executed. It was not. That judgment has already been made. The ship has already sailed. What is Lively doing here? I do not know. But at the end of the day, hopefully that judgment now will wake up a whole industry who've been like, well, it's just commonplace. We don't bother signing shit. Maybe you should start. Maybe that court order from Lyman on the summary judgment is, a hint that you need to start doing that. Not send in an expert to try and say, well, this is a commonplace thing. It's just how we do things around here. Oh my God. I'm disappointed with this argument. I'm disappointed that it's being brought in after a decision is already made. Like, I hope Judge Lyman tells this guy to go fuck himself, personally. And if he won't, I've just done it. In my experience, this practice in which talent and production companies and studios treat the terms of an unsigned long-form agreement as operative and binding is common in the entertainment industry and is known to actors, their agents and representatives, production companies and studios alike. In my decades of experience negotiating talent agreements on both sides, I've many times encountered situations in which the parties commenced and completed work on a production without ever executing the long-form agreement, while all parties nonetheless conducted themselves in accordance with the terms set forth in that agreement and operated pursuant to the understanding that the undisputed provisions of the agreement were effective and binding on all parties. Now, that's annoyed me, right? Because he's sitting here like saying, oh, well, this is common, studios and actors and all that, but this is normal. Then everyone understands that this is binding despite the lack of signature. Wayfarer were pressing and chasing Lively for that signature. Right? He cannot come in here and sit and go, well, I can speak to the mind of, he can't speak to the mind of Lively or what she was negotiating at the time, what her representatives were negotiating at the time, and he cannot speak to the mind of Wayfarer or It Ends With Us movie. But we can see from the email saying, can you please sign this? Can you sign this? Can you sign this? That, all that correspondence, making those requests, being sent to Library, we can clearly see that, Wayfarer, that was like that was necessary for Wayfarer. But also, The contract was not deemed executed without that signature, and the signature did not come. And, Lively is going to have to suck that up. But I actually, like, they're trying to make, say to the judge, hey, my experience, all this experience I got, this is standard practice, and, all parties operated as if it was binding, purely to try and get in that California choice of law provision. That's what this is designed to do. I think it's a crock of shit. I think it means nothing. It stands for nothing, because he was not part of the negotiations of the contract, and he is just coming in now for no other purpose than he is, like, California-based entertainment attorney, and he is saying, well, he's basically advancing Lively's argument, completely forgetting that Wayfarer over here, and it is blatantly obvious that they needed the document signed. Hence, they asked for Lively to sign it a lot. No, I'm not happy with it. I'm not happy with this document. I'm not convinced by the other one, but I'm not happy with this. Yeah, I need to go and make a cup of tea now. All right, guys. Please do like and subscribe, and if you can, please hype my videos. I will be continuing throughout today, tomorrow, and Monday with the opposition to the Dalbert motions too. And I will do an order has come in as well from Lyman, so I will get to that and go and see what that's about as well. All right, guys. Take care.